Throughout my practice, I do get calls regularly from people asking, do I have a case for wrongful termination? Hi, my name is Anna Salusky, and I am a local Southern California employment law attorney. Today, I'd like to talk with you about what qualifies for a lawsuit for wrongful termination, and also go over some examples where people may think that due to the circumstances that they faced in the workplace, it was unfair, they weren't treated in a respectful manner, but it doesn't necessarily give rise to a case for wrongful termination. First, I'd like to talk about some examples of what would not qualify for wrongful termination. First example, which is a very common one, is your boss is just a jerk. Maybe your boss yells in the workplace, he's disrespectful, he makes overwhelming demands. All of these things definitely are unfair, they don't feel good, but it's not alone enough to support a case for wrongful termination. A second example would be you're in the workplace, but you're not getting the mentoring that you need in order to be successful. Again, this feels incredibly unfair, and you may be seeing other coworkers who are getting preferential treatment in terms of more mentorship opportunities and more growth opportunities, but unless it's somehow connected to you belonging to a protected class, that alone is not enough to give rise to a case for wrongful termination. A third category would be you just don't really like your boss. Again, your boss may not be a great person to work for, may not have the leadership skills that you would hope for, but again, this alone is not enough to support a case for wrongful termination. Another example can include just being given a more heavy workload than your coworkers. If it's driven by the fact that you perform better than your other coworkers, that is not an example of a case for wrongful termination. Another example that I get a lot of questions about is poor performance in the workplace for circumstances that are beyond the employee's control. That could include a situation where an employee is responsible for rolling out a project, but isn't being given the staffing resources to get it done on time or get it done as effectively as possible. Another example would be where an employee is responsible for cleaning up another coworker's messy files or disastrous management of their workload. Again, even though it feels patently unfair, that alone does not support a case for wrongful termination. A final common example that I hear about from prospective clients is the situation where there are personality conflicts in the workplace. Now, a personality conflict potentially could give rise to a case for wrongful termination if it's based upon you belonging to a protected class and that coworker or boss doesn't like you for that reason. But if it's simply our personalities clash, we don't get along, we don't particularly like each other, that alone does not support a case for wrongful termination. Well, what are claims that would qualify for wrongful termination? In order to have a claim for wrongful termination, an employer has to violate either state or federal laws that protect employees based upon belonging to a protected class. Some examples would include a discrimination claim in the workplace based upon the fact that you belong to a protected class based on race, gender, ethnicity, religion, sexual orientation, or some other protected class. Another example would be retaliation in the workplace. An employer cannot terminate an employee for filing a case for discrimination or harassment, or reporting an unsafe working condition, or for asking for their unpaid wages. A third category that could give rise to a claim for wrongful termination is when an employee engages in protected activities and becomes a whistleblower in the workplace. And we will talk more about that in one of our other videos. Another category that would give rise to a claim for wrongful termination is in the circumstance where you have an employment contract with your employer and the employer decides to breach a term of that written agreement and terminates your employment. These are rare cases because California is an at-will employment law state, And in most cases, employees do not have contracts, but in some instances it does apply. Another category of wrongful termination would be a situation of constructive discharge, where no reasonable employee would remain in a workplace given the kind of behavior that is happening based upon them belonging to a protected class or based upon them reporting something that was illegal in the workplace and then being retaliated against for it. Another example would be termination in violation of public policy. An employer cannot terminate an employee for exercising a right such as voting, reporting for jury duty, reporting an illegal activity, or even running for public office. The final category for wrongful termination would be an involuntary termination, where an employee is pressured into giving their resignation or coerced into giving their resignation after having experienced one of the illegal activities that we just talked about. If you're in California and you believe that you have been a victim of wrongful termination, please feel free to reach out for a free consultation to discuss the circumstances of your case. We'd be happy to talk. Thank you for watching this video. If you liked it, please feel free to leave any comments and also like the video. If you know anyone who could find this information helpful, please forward it on to them. And if you'd like more information about other employment law topics, please feel free to subscribe to my channel. For everyone else, I'll see you in the next video.